Let's now consider Chapter 18, Abnormal Psychology in the Law. We'll start with a few basic terms that you might be familiar with. Confidentiality basically means what happens in therapy stays in therapy. There are three notable exceptions. See if you can name one or more of them. The person has shared that they are planning a serious crime. The person, according to your professional estimation, is a danger to themselves or others. And the person is a minor, an elder, or another protected class, such as an intellectually disabled person. Under these considerations, you cannot maintain confidentiality. Of course, as a therapist, you need to share that with your client before they disclose any of these particular issues. Some students confuse confidentiality with privileged communication, and that makes sense because they are conceptually similar. But privileged communication specifically relates to a courtroom situation. The mental health professional is not permitted to share the information with a court unless they are permitted to do so by their client. It's recognized in various professions. Can you name a few, perhaps? So a similar circumstance exists between a lawyer and their client, and it's rather parallel to the situation between a priest and their parishioner, amongst other situations. Before you leave this course, I want to make sure that you're familiar with the ideas of Thomas Szasz. He wrote the famous book, The Myth of Mental Illness. He thought that the idea of mental illness was a way to control people and to make people all walk to the same drummer, if you will. He did slightly step backwards from his viewpoint to allow that schizophrenia was a true mental illness, but in general he thought it was a societal way of controlling people. He preferred to use the conceptualization problems in living versus mental illness. A very extreme and radical viewpoint, but perhaps worth considering and perhaps with a little bit of merit. If you watch shows like Law and Order, you're probably familiar with the duty to warn principle, sometimes called the Tarasov principle. It was named after Tatiana Tarasov, who in 1969 was brutally murdered by a graduate student. The graduate student was obsessed with her and had seen the mental health professional of his university and Tatiana's university. He indicated that he was planning to murder Tatiana. The therapist thought it to be a credible threat. The therapist contacted the university police, who interviewed him and thought he was perfectly safe and just told him to stay away from her. Upon her death, the parents sued both the doctor and the university, that is specifically the university police, as part of the university. Their lawsuit came to nothing. The therapist did his due diligence according to the law then. He contacted the university police. The university police were held to be unaccessible for lawsuit, and nothing came of it, with the exception that the duty to warn principle was adopted by many states. So if a mental health professional is seeing someone and there's a credible threat in their estimation to a specific person, that therapist has obligation to reach out to that specific person and share the threat. So this is our duty to warn principle. Perhaps you've also heard of Kendra's laws from your TV viewing. Kendra's law allows court-ordered outpatient treatment. So it does not allow forcible medication, just court-ordered outpatient treatment. In terms of a little bit of background, in 1999 there was a rash of violent crimes committed by mentally ill people. In two very similar assaults in the New York City subway, a mentally ill person off their meds pushed Kendra Webdale to her death in front of an oncoming train. Kendra's law is named after her. Her family played a very significant role in getting it passed. At about the same time period, another mentally ill person pushed Edgar Rivera onto the subway tracks, causing the loss of his legs. In terms of what happened to Kendra's attacker, Andrew Goldstein, he was sentenced to 23 years, served 19. So he was not able to use, or did not choose to use, the insanity defense. He was released from Sing Sing in 2018. During his crime, he was psychotic. If you watch TV crime dramas, such as Law and Order, or whatever your preference might be, the term competency to stand trial occurs quite frequently. It does not refer to their mental state or status at the time of the crime. It only looks at their status at the time of the trial. They have to be sane enough to appreciate the charges against them and to participate meaningfully with their lawyer in their defense. Let's consider the insanity defense in terms of its history and how it's currently used in the U.S. Let's start with how often it's used. You may or may not have covered this in Intro Psych. Do you think it's 1% of criminal court cases? 8%? 12%? Perhaps more? Would it surprise you to learn that it's used in far less than 1% of criminal court cases? Let's now look at the history of the insanity defense very briefly. American law is based on English law. It sets some of our precedents. So that brings us to the Macnaghten rule. In English history, a mentally ill man thought God wanted him to kill the Prime Minister. He missed and instead killed their Secretary of State. His lawyers thought he should not be found guilty because he did the act because of mental illness. They argued cannot tell right from wrong due to mental disease or defect. And so that precedent came into law. Now, if that sounds vaguely familiar, it might remind you of modern times in the United States in which John Hinckley shot and wounded then President Ronald Reagan. Why did John Hinckley do that? He thought that it would impress Jodie Foster, the actress. Again, this was a result of delusional thinking related to his then active, untreated schizophrenia. But in any case, think of Macnaghten in cannot tell right from wrong due to mental disease or defect. Other previous laws or tests include the Durham test. This is used when the crime was caused by a mental illness. This was found to not be workable. So if a person drinks alcohol, gets into a horse and buggy accident, which would be the time of this act, and kills somebody, they're not guilty because their alcoholism caused them to drink. Or if their alcoholism caused them to lose their temper and kill somebody, obviously that wouldn't be acceptable to our society. So this was of limited use for a limited time period. We also had the precedent of the irresistible impulse. The person could not stop themselves. For example, a man comes into a situation where his wife is having intercourse with their next door neighbor and he kills them both. It would be argued the irresistible impulse. Again, not very useful. No previous mental illness. The person just could not stop themselves. Let's consider the modern standard. The modern standard was created by lawyers, not by mental health professionals. It was created by the ALI. You think, could that L be legal? Law? Lawyers? Definitely one of those. American Law Institute. Used when the person with the disorder either cannot appreciate the wrongfulness of the act, basically is unable to tell right from wrong, or they could not conform their behavior. In other words, they could not stop their behavior. And again, this requires a pre-existing mental health condition, can be spontaneous on the spot of the crime. Now that we've considered the history of the insanity defense, let's look at how it's applied in modern times in the U.S. We should note that insanity and the insanity defense is not being defined by mental health professionals, it is being defined by lawyers. Let's consider the ALI, and that's an acronym you should probably know given what we're talking about. It would be American Law Institute. As a mnemonic, so you don't mistakenly think it's American Legal Institute, notice that ALI has 3 letters. The word law has 3 letters, so that should help you remember it, I hope. But in any case, the ALI's modern penal code rule combines the McNaughton rule that we've discussed previously and the irresistible impulse rule. And this ALI definition is used in about half of the states, including New York. Roughly the other half of the states use the McNaughton rule alone. By using either one of them, the defendant is admitting guilt to the crime. And for both, a mental health professional must testify supporting their use of that particular explanation, that particular defense. 4 states have no insanity defense at all. Do you need to know them? Not really. If you're curious, it would be Kansas, Idaho, Montana, and Utah. I thought we would consider 2 modern cases of mentally ill people doing violence to the famous people. As you can see, this is John Hinckley. Do you recognize the woman? She is actress Jodie Foster. Hinckley was obsessed with her. You can see the note. What could he give a famous actress that she didn't have? Well, it was the assassination of President Reagan. President Reagan was actually hit by a bullet under his arm. It was a non-serious injury. Hinckley spent 41 years in a facility and was released at age 67. Another modern case of a mentally ill person killing a famous person would be the murder of John Lennon. He was murdered by Mark David Chapman back in 1980. Chapman has been in jail downstate in New York ever since then. Please don't walk away with the perception that mentally ill are dangerous. As a group, they're actually less likely to be involved in violent crimes than the mentally healthy people. So the vast, you get the idea, majority of murders and violence done in this country are not done by the mentally ill. They are done by the mentally sane and many times morally bankrupt. Let's consider the general term commitment and look specifically at New York State. The term commitment refers to the involuntary placement of a person with a mental health disorder in a mental facility. There are 2 types. The person has committed a crime. The other type, the person has committed no crime, and yet you're going to place them in an institution. Now, in New York State, a person can be held for up to 15 days if there, and here's a quotation, if there is a likelihood of serious harm. Now, for long-term commitment, and this is according to the New York State Mental Health Hygiene Law, Section 9.27a, and no, you do not need to know any of the specifics on that. The documentation of that law allows a hospital director to retain a person in their facility if two physicians give documentation that the person's mental illness requires inpatient treatment and there is a threat to them or another person and that person's mental illness prevents them from understanding this. So it has to meet those criteria. Now, additionally, a close relative, father, mother, brother, sister, child. Additionally, a close relative or spouse may also initiate a request for a hospital evaluation. I've attached a guide for New York State there. You don't need to click it unless you have personal need or perhaps you'd like to learn more about the details of the subject. Let's consider the general term commitment and look specifically at New York State. The term commitment refers to the involuntary placement of a person with a mental health disorder in a mental facility. There are two types. The person has committed a crime. The other type, the person has committed no crime, and yet you're going to place them in an institution. Now, in New York State, a person can be held for up to 15 days if there, and here's a quotation, if there is a likelihood of serious harm. Now, for long-term commitment, and this is according to the New York State Mental Health Hygiene Law, Section 9.27a, and no, you do not need to know any of the specifics on that. The documentation of that law allows a hospital director to retain a person in their facility if two physicians give documentation that the person's mental illness requires inpatient treatment and there is a threat to them or another person and that person's mental illness prevents them from understanding this. So it has to meet those criteria. Now, additionally, a close relative, father, mother, brother, sister, child. Additionally, a close relative or spouse may also initiate a request for a hospital evaluation. I've attached a guide for New York State there. You don't need to click it unless you have personal need or perhaps you'd like to learn more about the details of the subject. Let's look at legal precedents in which the basic rights of either the intellectually disabled or mentally ill were obtained, not through gifts, but by court battles. The first case, Addington versus Texas. Specific to involuntary commitment to a facility. In the past, people were placed in facilities when they did not represent a danger to themselves or others. They were simply violating social norms. Or there might be a potential vague and unsubstantiated for danger. This standard is that there must be a clear and present danger to deprive somebody of their civil rights. The next case, Wyatt versus Stickney, establishes minimal standards of care such as treatment, such as privacy, such as clothing, to get mail, to get adequate food, and food of a reasonable quality, and so on. Basic human standards that should not have to have been fought for, and yet they were. Next case, O'Connor versus Donaldson. This is not related to involuntary commitment, but rather long-term confinement in a facility. This is deemed appropriate only if the person was dangerous. Many people were being incarcerated just because they were not getting better because adequate treatment was not being given and the conditions were so horrible that it actually made the mental illness worse. So custodial confinement must be when needed, that is, if the person is dangerous to themselves or others. And if these basic tenets are not met, this case also established precedent to get cash awards when the person's rights were violated. Next one, Youngberg versus Romeo. The person must be placed in the least restrictive circumstance and environment. So if they can be treated successfully with outpatient care, that should be used instead of inpatient care. If it must be inpatient care, they should give free access to the ward facilities. If that's not possible, again, so you can't put a person in a straitjacket or solitary confinement. If a lesser circumstance and treatment would be effective and safe. Last one, Rogers versus Oken, established the right to refuse some types of treatment. So you have 5 court cases you should learn the very basics of. And for each one, I'm going to give you a mnemonic. Some are better than others, and I admit some are rather lame or limited, but if you find anything more clever that you can think of, by all means, share it with your classmates and share it with me. Okay, first one is Addington versus Texas. So I want you to think about Texas. What comes to mind in Texas? And think of it in terms of a dangerous state. Why dangerous? Tornadoes, floods, the Wild West. But think of Texas as being dangerous. Okay, so if we use that, relate it to the idea of clear and present danger required for involuntary commitment. So it'll get you thinking about the idea of dangerousness, and hopefully you'll be able to cue into the more specific concept needed. Wyatt versus Stickney. You might wonder, why is the S bolded? The S is going to catch your eye, hopefully, for standards. It establishes minimal standards of care, but don't expect to see the bold S on a test or quiz. So Wyatt versus Stickney, focusing on the S for standards. Next one, O'Connor versus Donaldson, and this requires that you be willing to misspell O'Connor with 2 C's. It doesn't have 2 C's, but pretend it does, because we can use those 2 C's for custodial confinement. Custodial confinement is only allowed if the person is dangerous, and if it is inappropriately used, we can get cash again. So focus on that 2 C's, even though, again, it really doesn't have 2 C's. Next one, Youngberg versus, what's Romeo, but let's read it as Romeo. Think of Romeo and Juliet, the young lovers. The 2 families tried to restrict the young lovers, and it ended in disaster, both their deaths. So think of it not being good to restrict the young lovers. It's not good to restrict Romeo and Juliet. Again, they'll help you think of Romeo as that's the Romeo one. Don't restrict the young lovers. So again, hopefully that will help you think of least restrictive environment. And the last one, Oken, kind of like the word oral. It begins with the O, 4 letters, short word. Okay, so think of oral as in maybe oral medications. So Oken, I know this is pressing and it's a jump, but it's the best I can help you with. So Oken like an oral, so right to refuse basic treatments like oral medications. So if it's useful, use them. If not, well then find another way, just maybe perhaps writing them over and over. You've probably all heard of court cases in which the person confesses only later to recant, to take it back. You might think, well, that person was certainly guilty. And if you're in a jury, most jurors would probably think the same thing. But can false confessions be artificially created in the laboratory or in the real world? Well, in terms of the real world, yes, and in terms of laboratory investigations, most find that between 19 to 25% of subjects, basically 1/4 to 1/5, can be induced to give a false confession of a event that potentially could get them on academic probation at college or dismissed, fired from a job. So you wouldn't think it would happen in the laboratory situation or the real world situation, but yes, it does. More frightening, perhaps, again, the case of a person that's been arrested where their freedom might be at stake. Go to the attached clip on from the California Innocence Project, and you'll see a particular case of false confession. Don't be at all surprised to see this particular video clip forming the basis of one of your lecture/PowerPoint quiz questions. I think you'll find it very interesting. Let's consider eyewitness testimony. Perhaps someday you'll end up on a jury. Perhaps that will be a criminal court case in which the person's freedom might be at stake. Jurors are typically very impressed by eyewitness testimony. They put a lot of stock into it. They put a lot of weight into it. But should they be that impressed? Should they put that much weight into it? Go to the attached clip from the California Innocence Project, and you might get some rather surprising information. Don't be surprised if you see a question from this particular video on your quiz.